Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Matthew Hall and my co-host today is James Hunsberger. Hello, James.
Hi, Matthew. Great to be here.
Today's episode is any deal safe from review in the EU? Implications of the Towercast judgment. We'll be discussing the merger control implications of that 2023 ruling from the EU's highest court, the European Court of Justice, or ECJ.
And our guest today is Frédéric Manin. Frédéric is a French avocat or lawyer at the law firm Advant Altana in Paris. He specializes in EU and French competition and antitrust law, acting for large French and foreign companies active in a wide range of sectors, including the insurance sector. Hello, Frédéric, and welcome to the show.
Hello, James. Hello, Matthew. Very happy to be here with you.
Well, thanks for coming on, Fred. Just as a reminder for our listeners, the basic merger control structure in the EU is that large transactions, those where the parties have turnover above certain thresholds, are reviewed at EU level under the EU merger regulation, the famous EUMR. Transactions whose parties are below those thresholds can be reviewed at national level in the EU if the relevant national thresholds are met. The ECJ's ruling in the Towercast case confirmed that when a transaction falls below the EMR and relevant national thresholds, the member state regulators in the EU and the member state courts can instead use general competition law to review a transaction, and even after closing. And the reason for that is those general competition law rules are contained in the main EU treaty and are therefore primary EU law that cannot be overridden. So, Fred, Towercast is therefore about review of below threshold transactions in the EU. Can you please remind us briefly of some of the recent issues around that topic?
Yes, happy to. As you mentioned very rightly, we were living in a world of reasonable legal certainty. I mean, once the thresholds were met, either for EU dimension or on a national level, filing is mandatory, and that gives rise to a long period of time during which there are exchanges with the regulator, the relevant regulator, and that gives rise to a decision of approval with or without undertakings. And the principle was really that if you fall under the relevant thresholds, there was no filing. I mean, it could be probably still caught by the rules on anti-competitive practices. But the idea was that you were more or less in a safe world. And with the Towercast ruling of 2023, that has changed dramatically the scene, because we're getting back to, in some ways, to the continental can, very old case of 1973, which means that probably more for complex or strategic transactions, there may be control ex post of the said transactions, if basically we are talking about the market, which is national in scope. So the whole system is to say that the transaction can be caught either, and we'll probably get back to this, either under the rules prohibiting abuses of dominant position, if basically the concentration, if the acquisition of control was implemented by a dominant player, or on the grounds of anti-competitive arrangements, practices. So the companies have to be aware now, and that has changed very much also our practice as antitrust lawyers. The companies have to be aware that it's not because there is no filing that they will be in a safe world. And the problem also is that their behavior and the operation may be caught a long time after the completion of the transaction, which obviously raises substantial problems.
Yeah, and I think it's worth noting as well, Fred, that the ECJ's judgment in Illumina Grail, which held that the European Commission cannot accept referrals up to the European Commission unless a member state itself has jurisdiction, really has brought this Towercast case into sharp relief, hasn't it? It's made it quite a lot more relevant and important.
Yeah, exactly. There was an initiative started by a lot of authorities representing different member states. Idea was to rely on Article 22 of the EMER to review concentration below national thresholds. But the Court of Justice quashed the judgment by the General Court, insisting very much this time on the need for foreseeability and legal certainty. So that means that you cannot rely on this to have a below threshold transaction being reviewed by the Commission. So that gets back to two different systems, either the Towercast regime or the call-in powers by various authorities. And we have to know that, to be aware that within the EU, there are 10 member states. Actually, there are 10 EEA member states, which already have calling mechanisms in place, and others are seriously considering implementing this system. But also, there's immediately the question of the deadline, of the timeframes, because the key question is, until when can an authority implement this power to control ex post a transaction? There are examples, for example, in Ireland, there is a limit, which is a limit of 60 days after the completion of the transactions for this ex post review to be conducted. I was thinking of another system, but we are talking this time of a system outside of the EU, a completely different system, which is very modern, which has been implemented at the end of 2025, which relates to the common market for Eastern African countries. And that's a very modern regulation, actually. And there's this regulation 41, which says that the Competition Commission may review ex post non-notifiable mergers, but provided that the merger has not been implemented yet. And the question of interpretation is, what do we mean exactly by implementation of a transaction? So this calling power system is another way to answer the question, but some have argued that it should be reduced to some sectors, economic sectors in particular. It should exclude others. And there's also the question of the interaction of this calling power with the regime initiated by the Towercast ruling. But basically, there are two different ways to review ex post a transaction.
Thank you, Frédéric. That's a very helpful overview. And it sounds like in the Illumina Grail decision, the ECJ was in particular concerned about predictability and certainty. Mm-hmm. It sounds like, on the other hand, the Towercast regime potentially introduces a good amount of uncertainty, which can chill business planning. And so I'm wondering, from the perspective of a U.S. practitioner trying to advise my clients, are there any limitations on the scope of the Towercast judgment on its face?
Well, the ruling introduces a number of criteria and factors. It has to, but again, it relates only to application of 102, so the issue of abuse of dominant position. the operation has to be implemented by a dominant player, which acquires control of another undertaking, and by this conduct, by this operation, um, the result is that it would substantially impede the competition on that market. The Court of Justice, the ECJ, has made it very explicit that the mere strengthening of a dominant position is not sufficient to fall under this new regime. It has to be abusive. So we are talking about the distinction between structural operations and really competitive practices or anti-competitive practices, but the line is very thin. There's also the fact that deriving from this judgment that it relates only to markets which are national in scope, and the odd thing also relating to the Towercast is that as we're talking about application of primary EU law, the ECJ has made it very clear that there is no limit which should be applied to the temporal effects of the ruling, because interpretation is clear or was clear from the outset, which may be questionable. But that means also, again, that when we deal with what we think is a strategic acquisition in strategic sectors like the digital sector, the defense sector, it's true that we are going to immediately assess the rationale, the objective underlying the acquisition itself. If the idea is to kill the competition and to kill really the probably the most challenging competitor, you are in trouble in the sense that we think that in itself may constitute an abuse, and we have already precedents. We have already cases from national authorities which have explored very thoroughly the objective based on internal documents, based on memoranda from external advisors, the objective which was pursued by the initiator of the concentration. So everything is scrutinized now, just to the effect of checking whether it was a sort of standard concentration, standard operation, or if the idea was really to remain just on its own as the dominant player on the market and to have no serious competitor, with the effect of potentially increasing the prices. And that would amount to an abuse of dominant position reportable under the Towercast ruling.
That really does sound like a pretty expansive authority on its face. And as you allude to, there have been some cases recently, and looking at some of those cases might help illuminate where the authorities are focusing. So could you focus in on one of the recent Article 102 examples? I understand there was a recent high-profile case involving Doctolib.
Yep. Exactly. Yeah, Doctolib is a very good illustration. It's a decision by the French Competition Authority, which was issued in November of 2025. What is quite odd, again, is that the authority used a simplified procedure to reach this decision. That means that the due process was quite limited. The observations were limited to the full extent possible. And the other interesting thing is that and there's this decision is under appeal right now. But the other interesting thing is that we are talking about a concentration, an acquisition by Doctolib of one of its main competitors, which is Mon Docteur, which took place in 2018. So it's 7 years ago. In terms of context, what we should know also is that there were two practices at stake in this case. There was really what we could call the very standard abusive practices, which were exclusivity provisions and tying. And on the other hand, there was this acquisition of Mon Docteur by Dr. Lieb. And we may wonder if the first practice, exclusivity and tying, had not been identified. We may wonder really if if there could have been sanctions applied to the second part of the case, which is really the acquisition itself. The fine was relatively symbolic. We're talking about only 50,000 euros because the FCA, the French Competition Authority, recognized that there was back then a lot of legal uncertainties. But the demonstration focused really on identifying Dr. Lieb as the dominant player when it took over Mon Docteur, and the fact that he was an increasingly dominant player after the completion of the acquisition. And the other part was also very much a strategy which was pursued by Dr. Lieb, and it resulted very clearly from internal documents, from memoranda, even from a press release which was issued for, just to announce the acquisition. It resulted from the whole thing, the fact that the idea of Dr. Lieb was really to make its closest competitor exit from the market, disappear, just to be able to become number one, far from any other competing undertaking. And that could give the possibility to Dr. Lieb to increase the prices substantially vis-à-vis the doctors, vis-à-vis the hospitals which used its services. An interesting question is to ascertain to which extent that would be an extensive interpretation of the Towercast ruling. It's true that the FCA relies very much on the principles which were underlying the Continental Can judgment. It used very much the notion of countervailing power. So really, we are very much at the core, at the heart of the notion of the abuse of dominant position. Dr. Lieb tried, in this case, to exploit the reference in the Towercast judgment to the behavior of competitors depending on the dominant undertaking. And the position of Dr. Lieb was to say Towercast should be used only if there is a vertical or a conglomerate link between the dominant player and the others. But the FCA refused this line of reasoning. It did not work. It said that that could not be inferred from the Towercast judgment. And it said also that size does not matter. Even if we're talking about an acquisition of a small company, it would still fall under the ambit of the Towercast judgment. The thing is, when you read this case, which is, it's a quite long ruling, we still wonder at the end of the day whether the practices themselves are easy to identify. It is true that it's not only strengthening its dominant position, but again, it's not that easy to see exactly which practices, which are different from the operation itself, were carried out by Dr. Lieb. Probably one of the main factors was the fact that there was this price element, the fact that Dr. Lieb really was willing to exclude from the market Mon Docteur, so to give itself really the possibility quite quickly to increase the prices. Last thing on this case, I like to say is that the effects were noticed some years later after the acquisition, but quite paradoxically, the FCA found that the practice was not continuous, but rather instantaneous. So it's quite probably a contrast, and it's not that consistent, saying it happened at one time, and at the same time you just consider the pricing elements and you consider all the strategy just backwards, because you have many years to reflect on exactly what Dr. Lee did after. And that helps really the FCA to assess exactly the matter and to consider that, yes, Dr. Lee did and committed an abusive practice. So it's a very interesting again, it's a very interesting precedent, but it's probably questionable from different angles, and it really remains to be seen whether the Court of Appeals will or will not confirm this decision by the FCA.
Indeed, Fred, and those are very interesting comments on the case. Just to give some background, I think it was held to have a dominant position in the appointment booking services market, not least because it had shares above 50% continuously for a period, and in some years above 90%. So it was looking at quite high shares. And I thought you made this comment as well, but the internal documents were really pretty damning in this case. I heard references to wanting to kill Mondocteur's product, remove a competitor, and also quotes, the creation of value is not the addition of Mondocteur, but its disappearance as a competitor.
Yep.
So, pretty amazing internal comments to have allowed to be produced in that case. But as you say, it'll be interesting to see where the appeal goes.
It was a market characterized by high barriers to entry also, and the networking effects, and that plays definitely a role in the decision by the authority to say dominant position is definitely not questionable, and that also plays probably a role in defining the abuse itself.
Yeah, absolutely. We've also indicated that the Towercast case doesn't only apply to abuse of a dominant position, but it can, and this was also mentioned in the Towercast case kind of in passing, but the use of Article 101, the basic ban on anti-competitive agreements under EU law, can also be used. And there has been, in fact, an earlier example in France, interestingly enough. So what happened in that Article 101 anti-competitive agreements case is applied to an acquisition.
Yeah, exactly. It's the meat cutting sector which was involved. So the FCA rendered a decision in May of 2024. Actually, it referred itself the case, so there was no complaint by any undertaking. The fact is that it's quite a complex case because at the end, the FCA says no, there is no anti-competitive practice. Decision was not appealed, so it's a final decision. Interestingly enough, and as you said very very well, Matthew, the FCA took the view that there is no reason to make any distinction between 101 and 102. We're talking also and all the time about primary EU law provisions which have direct effect. So the Towercast ruling referred very briefly to the application of Article 101, and the FCA from there stated very explicitly that concentrations may be caught against the background of anti-competitive practices, anti-competitive agreements. And it says also that there is no dependence for application of 101 on the Regulation 1/2003. So there is an equivalent system which should apply across 102 and 101. But at the same time, the authority considered that there was a series of transfers of goodwill by three companies within this sector, which happened more or less simultaneously. But the FCA, based on the evidence which was produced, said that there was no common or global plan to share the market, to allocate the market. between the three. They were only discussions, the purpose of which was to prepare the concentrations themselves. And it took very much account of the fact of different facts. One was the fact that there was no secret practice. Everything was more or less gave rise to legal documents, NDAs, which were extremely well structured. It took into account also the fact that the parties continued to act as competitors to each other during the negotiation process. And finally, everything revolved around the fact that the agreements were only designed to materialize the transfers of assets. So again, we were very much at the core of what defines a concentration versus what defines a practice. Um, and from there, the FCA said there is no restriction by object. But what also was relevant to the case was the fact that in the three companies did not really negotiate all globally. It was more, we are more talking about three sets of bilateral agreements. So the solution could have probably been somewhat different if some discussions could be interpreted as a means to really a global plan, a global approach, a global strategy, which was in the case at hand difficult to identify. Also, the authority conducted the analysis on the grounds of the restriction by effect, but very interestingly, and probably it's a bit frustrating as well, the decision-making body decided that there was not sufficient evidence produced over a sufficiently long period of time by the investigating services to identify really effects of these discussions and of this plan on the market. So at the end, yes, this decision is very important because it says there is no line to be drawn between application of 101 and application of 102, but it did not again identify the anti-competitive practices, and it's possible to probably say that they could be identified in very exceptional cases where really we need to demonstrate that there's a practice and not only an operation or a structural operation. And we need to also identify and qualify this practice having an effect on the market and being part of a large plan, which is either fixing prices collectively or sharing the market or other practices of that kind.
Yeah, it's something to think about. But for me, I thought it was quite reassuring, at least for applying 101 to, or not applying 101 to classic bilateral transactions, which meet a strategic objective and have actually a rationale and are publicized like normal transactions. Frédéric, before we look at practical issues of all of this, there are other investigations around the EU at national level, not only in France. So if you could just pick one of those to mention before we move on to practical issues, I think that would be interesting.
Yes, there's one that I found very interesting in Belgium. Actually, Belgium is has known quite a lot of cases following Towercast. It's the Proximus EDPnet case back in 2023 in the telecommunications sector. I think it's an interesting case because it really gave rise to a spectacular result. Proximus acquired EDPnet, which was really one of its, I would say, significant competitors. And the Belgian Competition Authority said there is a risk under the Towercast regime, a serious risk, and this risk is serious enough for me to issue interim measures, the purpose of which is to make sure that EDPnet is going to be acting still as a separate entity, even if it was acquired by Proximus. There are various teachings from this decision. One is that EDPnet was purchased by Proximus in the context of a judicial restructuring, but the Belgian Competition Authority said that's a different element, that's a different question. We're talking about a normal judge, which basically authorized the transaction, but within the context of its own rules. Does not have to have any effect on my power as a competition authority to consider that this acquisition may really give rise to significant antitrust concerns. Another interesting thing deriving from the interim decision by the BCA was that more or less the acquisition of ADPNet was relating to a neighboring market, not exactly the same market in which Proximus was active. And again, that did not prevent the BCA from considering that the Towercast regime and framework was fully applicable. And when I also mentioned the spectacular result is that the fact that there was an investigation pending, and in front of the difficulties raised by the Belgian Competition Authority, finally Proximus decided to sell the assets representing EDPnet to a new entrant, which is the company CityMesh. And from there, the Belgian Competition Authority said, we don't have enough resources. We're satisfied with the sale, but that means that the strategy pursued by Proximus was completely prevented and completely fought by these interim measures. So the concentration did not go to the end, or actually it had a very different outcome because, again, of the effects of the Towercast ruling.
Thank you very much, Frédéric, for this deep dive into some of these cases. To wrap up here, I'd like to focus in on some of the practical implications as a U.S. practitioner advising clients on global deals that have an impact in Europe and strong presence in Europe. I have a few questions that go to sort of key takeaways that clients should be aware of. So my first question is, does the Towercast judgment enable authorities to unwind transactions, or is it limited to fines?
It enables them to unwind transactions, and it depends also on very much on national regimes. If we talk, for example, about the French one, there is a provision which is very clear on that, and even we don't necessarily need to rely on the Towercast ruling, but it could go, it could go quite far, and I think that it would be in practice extremely difficult for any national competition authority to unwind transactions, but it's quite easy for them in some ways to, through, for example, the example of these interim measures, to make sure that the transaction is not going to give rise to the effects which were really pursued by the initiator of the transaction.
And given the expansive authority under Towercast, do you have any advice for clients on how to account for that authority or potential authority in transaction agreements?
Yeah, that's a very, very solid question. It's true that now more and more when we face some strategic transactions in strategic sectors, we need to provide different advice and strategic advice to the client, even again if the thresholds are not met. So that's really what we call now the Towercast advice, type of advice. One method is probably to use also the informal approach and to approach really the authority itself in anticipation of a transaction. If you know that it's a complex one, it could really give rise to potential issues afterwards. And I think that approaching it with already a very solid file saying there should not be any anti-competitive effects. Prices will not be affected in a major way in the future. I mean, there are probably ways and ways to go around this, but I think it's probably a good way to measure to which extent the authority would be keen in the future to conduct an ex post assessment or not. So that could give some reassurance to the client, even if it's partial reassurance, because we know that the authority will not commit itself completely during the course of this analysis.
And my last point, as Matthew alluded to earlier, in some of these cases, internal documents were critical. That will come as no surprise to experienced deal makers. But if you have one piece of practical advice for deal makers on how to minimize Towercast risk when it comes to document creation, what would you say?
That's a very good point, because we see at the beginning of the deal all the time PowerPoint presentations which really highlight the power of the market power of the acquirer, and how strong the undertakings involved are, etc. And we know that it's made by commercial departments, but we need now to tell them more and more, and again, very much in anticipation of any preparation of the transaction, we need to tell them that all these documents may be seized very easily by the competition authorities, and when they say one thing, it's extremely difficult to contradict this at a later stage. Or we know that even if there is no downgrade, the authorities may now ask whichever document they need for the conduct of their assessment. So I think it's something that we need to be involved as early as possible, and to say that these documents are not neutral. Sometimes I also always give I give sometimes the advice that some documents should be also drafted in a draft form, because that could raise to some discussions, because at the end of the day, even at least if they are drafts, we can always argue that the analysis was not definitive, and that was subject to further review and discussion. And that's always probably more helpful than having a document which is really in final form, saying that with such and such transaction, there will be no other player on the market.
Absolutely. The draft trick is something I certainly use. And I think before we move on, Fred, I mean, it's even more difficult with the situation like you referred to in EDPnet, where it was a neighboring market. So you weren't even looking at overlap markets, which really makes it kind of even more difficult to think about it in advance. So we like to have personal questions at the end of our episodes, Fred, as you know. So firstly, could you please tell us something interesting or unusual about yourself that is outside of your professional life and we would not otherwise know?
I don't know to which extent it's unusual. One of my favorite activities is to do cross-country skiing. Uphill in Norway, or whichever country in France, in Italy. I think it's a fantastic thing to know more about the mountains, because you are just on your own or with your group, with a tour guide, and it's a fantastic way to discover the mountains with no crowd, no queue for ski lifts or whatever. So great escape and great discovery of natures, whenever we do that.
You don't have to pay for a ski pass. And so what kind of distance would you do on a good day on a cross-country expedition?
It depends very much on how fit you are, but sometimes you can probably spend, I would say, 6-7 hours on the skis during the whole day, and within this period of time, I think that probably 90% is really going uphill and only 10% downhill. So it's quite you have to be in a good shape.
Great exercise. And now we have our curious hat.
And now it's time for the Curious Hat.
Fred, I know you are a listener of the podcast, so you know this segment is coming, but you don't know what question is coming because I've picked one at random here. If you could have free tickets to any musician or band, dead or alive, who would you choose and why?
Oh, okay. That's an easy one for me. There's no question. I want absolutely to attend The Cure. The Cure, which is this fantastic British band from the 80s. I know they're still giving concerts, even if they are probably over 60. And I would pay everything to attend their concerts.
Well, shout out to your friends and family listening. Next holiday gift.
Great, Fred. Well, that's wonderful. Thank you very much for appearing on our Curious Amalgam, and thank you very much to all our listeners as well.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.